Okay, it is 7:00 PM on Monday, May 9th, 2022. I would like to officially call the regular meeting of the Zoning Board of Appeals to order. If we could all please stand and face the flag and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Minnick, can we please have roll call?
Yes. Board Member Gazund.
Yes, here.
Board Member Krug.
Here.
Board Chair McAlpine.
Here.
Board Member Riley. Oh, no, sorry. That's Board Member McDonald. And he is absent. Board Member Euler.
Here.
Board Member Ward.
Here.
Board Member Williner.
Here.
All right, Madam Chair, you have a quorum of six present. You could ask one of the alternates to take Board Member McDonald's seat.
So what we will do then is if we can actually have both alternates come up, and we'll have you sit up here, and then if we can have Ms. Sayre sit at today's meeting because Mr. Riley sat at the last meeting. Thank you. So with alternate Sarah here present and sitting at the table, we will then have a quorum of 7 in attendance. Did we receive any kind of communication from Mr. McDonald that he would not be present?
No, we did not. That said, I did not reach back out to him this month, and I know he had a surgery.
So I believe I do need to take a motion we can make a motion to excuse Mr. McDonald without notice, at least for the record at this point, and we can follow up and see if
So moved.
something is happening with him.
Support.
So motion to excuse by Gazund, seconded by Euler. Gazund.
Yes.
Krug.
Yes.
McAlpine.
Yes.
Sayre.
Yes.
Euler.
Yes.
Ward.
Yes.
And Willner.
Yes.
Motion passes.
Next up on the agenda is the approval of the agenda, and you all should have a copy of that in front of us. And if anyone is in attendance, there are copies as well. When you came in, if you don't have one, you can feel free to grab one.
Madam Chair,
Yes.
can I clarify some things?
Yes.
First of all, you'll notice that all of you have correspondence on your desk and an email from Mr. Terrell, and he makes some very good points in the public notices, when it reads 320 Coolidge Highway, it reads between Earlmont Road and Brookline Hills. Brookline Hills is actually the plat, and that was my error, and I apologize. I was using the forms in building BS&A for the first time, which I don't think I'm going to do again. And so that came up as an error that I didn't catch. And also, on the notice for case PBA 0522, it reads on the east side of Woodward, and Mr. Terrell is indeed incorrect. Anything on the east side of Woodward is not in Ferndale, it's in Royal Oak. That said, I think you'll see that in his correspondence, he asked you to take an action for everything to be canceled tonight and renoticed. I just wanted to bring to your attention in the Michigan Zoning Enabling Act, a copy of which is on your desk about notices, when it says what has to be on the notice, it says indicate that the property is the subject of the request. The notice shall include a listing of all existing street addresses within the property. Street addresses do not need to be created and listed if no such addresses currently exist within the property. If there are no street addresses, other means of identification may be used. So all of the notices had the addresses on them in a correct fashion. I really, really do apologize for the mistake on the notices. It won't happen again. But please take that into mind when you are making a motion about whether to accept the agenda.
Thank you.
Welcome.
You made people make mistakes, what happens. So, given Mr. Terrell's, message here, and I will read it into the record, it was received on Friday, May 6, 2022 at 2:49 PM. And it says, if there is a ZBA meeting on May 9, please include this correspondence as part of the official meeting documents. I was reviewing the public notices for the upcoming May 9th, 2022 meeting and noticed irregularities that require that they both be not heard by the ZBA and they must be renoticed. Application PBA 0422 reads in part 3020 Coolidge Highway on the east side of Coolidge Highway between Earlmont Road and Brookline Hills. I am unfamiliar with the street name Brookline Hills, nor have I found it on the city map. Application PBA 0522 reads in part 28105 Woodward Avenue, 28151 on the east side of Woodward between Dorothea and Catalpa. If the property is indeed on the east side of Woodward between Dorothea and Catalpa, it would not even be in Berkley. Please cancel the meeting to hear these two applications until such time as the required public notices can be done correctly. And this was from Charles A. Chuck Terrell, and he did provide his phone number in the correspondence. So at this point, we also do have the Michigan Zoning Enabling Act. It's an excerpt of Act 110 of 2006. 125.3103, notice publication, mail, or personal delivery requirements. And there are, it looks like, 4 sections and then an A, B, C, and D under section 4. So I don't know if you all want a minute to review that or if we are ready to determine whether or not the request by Mr. Terrell is valid, or if we are ready to approve the agenda as presented. So I will entertain your thoughts and comments. Yes, Mr. Guzan?
The Zoning Enabling Act says that the street address needs to be strictly on Part B, says the street address is the determining factor, and that the description of the property of where that street address is if street addresses are not available. So as long as you have the street address, you should be able to find the property and know where it is.
So basically what we're saying is the descriptions are where the error is and not the
Right.
specific street address. Therefore, we would have complied with, it would be 4B, which says, indicate that the property is the subject of the request. The notice shall include the listing of all existing street addresses within the property, which the notice is due. Street addresses do not need to be created and listed if no such address currently exists within the property. There are no street addresses. Other means of identification may be used. So given that, if that is how we want to interpret what the Enabling Act says, then while Mr. Terrell is correct, there were some errors. They do not reflect the fact that the notices were done incorrectly and that we should not be hearing the 2 items on our agenda this evening.
My only concern is for the second application, 28105 Woodward Avenue, 28151. Seems like there's 2 address numbers, and I thought that was a little confusing when I looked at it. I'm not sure which one is the right one.
28105.
That's what I would figured, but that could be interpreted as slightly problematic. two addresses there. I kind of figured that too, but,
So all addresses involved in the, is, yeah.
So both
so
those
that-
addresses are correct?
Yes.
Essentially, they're both correct.
okay, I mean, a lawyer could probably poke a hole in that, but,
I'm the lawyer from that building, so if we could be heard and I guess.
if they're fine with it, that's,
Well, we need to determine if we want to approve the agenda, and then,
I think we gotta determine if we're gonna approve the notice, right, or,
No, you would approve the agenda. If you felt the notice was improper and needed to be redone.
then we would not approve the agenda as presented, and we would either choose to hear one, the other, both, or neither.
okay. I mean, I figured it out where it was, and I figured that's what it meant, so I assume most people do the same thing, which is pointing it out.
I'd like to move to approve the agenda.
Support.
Motion by Gazin, support by Ward.
I think it would be a disservice to the petitioner if we had to go through the re-notification process. So,
Did we receive any communication from anyone other than Mr. Terrell asking or confirming or verifying or saying they don't understand?
So there was a piece of correspondence to Mr. Baumgarten, the city manager, who pointed it, that Brookline is not a street. And then also, I spoke to Ms. Felinski, who has a letter that was in your packet regarding the first case at 3020 Coolidge. Who also shared the mistake, and I apologized, and we talked about where it was and whatnot.
So no one called and said, I don't know where this is?
No, they knew where it was, but they were confused by the reference to Brookline Hills.
Okay, but we clarified anyone who had reached out electronically, via telephone,
Yes.
in person, okay. Okay, then we can take a roll call to approve the agenda.
Gesund,
Yes.
Krug,
Yes.
Chair McAlpine,
Yes.
Sarah,
yes.
Euler,
Yes.
Ward,
Yes.
Wilner.
Yes.
Motion passes.
Okay, so we will move forward with the agenda as we have it presented. Next up would be the approval of the minutes. It would be our meeting minutes from our meeting on April 11th, 2022. Everyone should have received those. They were in the packet. If you have reviewed them and have any revisions, additions, or corrections, we can address those now. If not, we will take a motion to approve the minutes as, the draft of the minutes as presented.
Madam Chair, I'll move that we approve the minutes of the April 11th, 2022 board meeting.
I'll second.
Support.
So that was a motion by Ward, and then support by
You can say Wilner.
Mr. Wilner?
Wilner.
Wilner.
Thank you. Gesund,
Yes.
Krug,
Yes.
Chair McAlpine,
Yes.
Sarah,
Yes.
Euler,
Yes.
Ward,
Yes.
Wilner.
Yes.
Motion passes.
Next up would be old business. I do not believe we have any old business that we need to review. If there is none, we will move forward on to new business. First up is application PBA 0422. The address is 3020 Coolidge Highway. The request is for a dimensional variance to waive on-site parking requirements. Takesha DuBois, is that close? Did I say it? on behalf of Gary Imhoff at 3020 Coolidge Highway on the east side of Coolidge Highway between Earlmont Road and Evergreen Boulevard, is requesting a variance to allow waive of on-site parking requirements and rely on on-street parking only for a salon and a spa. Did I say, I'm sorry, Edgewood. Did I say?
Edgewood. You said Evergreen.
Oh, Everett, I'm sorry, Edgewood. With all our little streets, I'm all like, so if we can just have you present the background on the specific application?
Absolutely. So the zoning and land use surrounding this entire site and across the street on Coolidge is all zoned Coolidge District. The subject site is a 2-story building with retail on the ground floor and a vacant second story. Across the street is the VFW post. To the east is parking for the building to the south, and we'll get into how that was part of some of the parking in the back was originally part of this property. And then had new developments also today based on one of the letters of correspondence you got. The credit union is to the north, and then there's a 2-story building with office on the ground floor and residential on the second story immediately to the south. So this site has a pretty long history. I'm trying to hit the highlights of it. So one, a beauty salon was on the ground floor at this address. It received a parking variance on June 14th, 1990. And a copy of that file was in your packet. The variance was to permit a nail salon with 1 employee as a grandfathered use for a shop with no on-street parking. Spike Lawrence, then an awards and promotional products business, was given a business license in 2008. In consultation with the city attorney, it was determined that since there was a change of use in between the hair salon that got that variance and the applicant who's coming before you, that the variance is specific to a grandfathered use because the grandfather fell away when, or the legal nonconformity fell away when the use changed, that variance is no longer valid. You can see that the rear portion of the site was severed from the property and combined with 310 to the south. And that, looking into that lot split further today, so that happened, there were 2 things that happened, and I'm gonna pull up this diagram for you, and I want the JPEG. I apologize, we just saw this today. It was in a file folder that was not in our database, and so I'm gonna follow this up and then kind of walk you through where we are. And I'm sorry, it's blurry. I took it with my iPhone and didn't look at it closely. So this is the applicant's site. And you can see that it's much shorter than the site at 310. So this is 320, this is 310 Coolidge. And this is
The parking area.
the
behind.
parking area. And what this combination does is it takes, what happened before was, this was a lot, this was 310, this is 320, and this was a separate, we think, we need to do more research, but we think that was a municipal parking lot. Also, there was 4 feet here, so 4 feet deep, and the length of this plat wide, the length of this lot line wide, that was vacated and given to this parcel at 310 in 1999, and that was sold from the city. But at that point, there were these 3 parcels, this parcel, and this parcel. In 2015, so this is the most recent thing, there was a lot split done, and lot split in combination. So what happened is, this parking was then split off of this overall, off of 320, combined with this, and then those 2 were combined with this. Because if you go on to, if you look in at like Oakland County's Parcels Plus or whatnot, you'll see that even though you will see the original lot lines, and that they're separate parcels, that they all associate with this address. The reason, so any questions on that before I take that down?
Can I ask a question?
Yeah.
Was that approved by the city at that point?
How lot splits are approved is by state law, it has to be an administrative function of the city. So, and I have, I think that is that's the resolution to sell it. This is the lot split paperwork from 2015. So you can see that there are forms, and they come from Kim Anderson, the building clerk. Those probably would have been also, I talked to her today, she said those would have been reviewed by also Amy Vanson, who was your planner at that point in time. New child parcel information, I know that sounds odd, but there's a parent parcel, and then they have children, and there's only so many, and things like that. And you can see here some correspondence. Who ultimately approves it is the county. But the city has to sign off on it. So the city says it complies with our zoning. And as I stated in my review, it does comply with the zoning at 2015 and now. There's no minimum lot depth, there's no minimum lot width, and there's no minimum lot size for a lot on Coolidge. So there's nothing in the zoning that would compel someone to leave room for parking unless they took a second look or a second leap. And also the state act is really built for land division of vacant land with that in mind. And because that's the majority of where these happen. They don't necessarily, you don't see the number of lot splits that a rural township would. But that was a great question. So, and then I wanted to show you also, so that was going back to, if you can, while we're talking about the original split, you can see here that, so this is the site, and you can see that that's 5381 feet deep. And even if it had come up of here, this is 27 feet, so originally it had around a little over, this was 80 feet deep. The original plat was 132 feet deep. And you can see that pattern as you go up and down Coolidge. And when you see these 37s, that's the original plat, so 38s. That was the original plat back in probably the 1920s of the Brookline Hills plat. Which, and that also would differ as it goes over here. These, your typical lots over here are 40 feet wide and 135 feet deep. So that's, so if you look for something that's unique about the property, something that is really unique about this property when you look around is that it's only 53.81 feet deep. And if you look where the building is, you can see there's only about 5 feet there, and the a legal parking space is 10 feet deep, and usually a minimum of 8 feet wide. 8 feet wide. So you can't 20 feet deep, 8 feet wide, or 18 feet. So you can't fit in a legal parking space with the building as it sits and the lot as it's configured, unless you were going to take off part of the building. Also, from the correspondence that came today from Dennis and Jennifer Hennon, mentioned that it seemed like there was public parking before, when it had been vacated, had this happened at the same time. What you can honestly say is that the lot split and combination happened in 2015, well after whatever municipal parking was there, whether it was on street, along Edgewood, thank you. Edgewood, or whether it was actually in that third parcel in the back. Now the applicant filed for a business license on March 4th, and the business license states that the salon will operate Monday through Saturday with 3 employees. It also states that the applicant has been told that they could park at the VW Hall or the Vibe Credit Union without an agreement. But today, we saw Kim Anderson found in records, and it's just a listing of places with shared parking agreement that was made by Amy Vanson before she left. And it listed 310, the addresses for 310, 320, and the Vibe Credit Union, all as having a shared parking agreement. We can't find that parking agreement. We looked, the clerk had left by the time we found where it was. So there could be a possibility that there's actually a shared parking agreement somewhere, but also I know I sat down and met with the applicant, and she was told by the building owner that they had sold all the parking and there was none available to whoever the future owner is. So while tempting, it might be very difficult to find. Also, we checked any recordings at the county that were available electronically and didn't see any. Again, it was what we could do this afternoon. So her, never to say, her business license is on hold, and her real estate agent met with me on March 9th, and we went through what she would like to do, including the first floor as a day spot, but she was unsure of plans for the second floor. They were concerned about parking, and she said that her appointment is by, her business is by appointment only. So the requirement for 3 parking spaces per chair or service station didn't comply with how her business would operate. I do agree, though, with with, again, Dennis and Jennifer Hennon, who wrote to you that that's pretty hard to enforce in terms of how you would do that by your code enforcement officer. I advised her she could consider applying for the variance for parking. We discussed that the parking credit would allow parking to be reduced by 2 spaces on site by providing 4 bicycle spaces, and that's with the installation of 2 bike racks. In the variance application, she indicated she'd be willing to install those bike racks and to give parking instructions to all employees and clients. There are 5 on-street parking spaces in front of 320 and 310 Coolidge. I'm sure you all did site inspections. I did a site inspection when I was there. I saw 2 cars parked in front of that block. And then we've already talked about the error notice. So essentially, they want to waive the 9 spaces, which technically could be 7 if the bike racks were installed, but since they're not, that wasn't part of the notice. That's something that they're offering. And then in terms of your standards, I really do feel that there is a unique circumstance to the property. It's very shallow with a depth of less than 54 feet. And we've gone over how that's different than the original plat and other parcels in the area. One of your standards is the need for the variance is not the result of actions of a property owner or previous property owner. This is the result of an action of a previous property owner. However, again, as I stated, there's no minimum lot size requirements or lot width, so there was nothing really to prevent this from happening that's within the zoning ordinance, and it was done in a legal way. Strict compliance with the ordinance will unreasonably prevent the property owner from using the property for permitted use or render conformity with those regulations unnecessarily burdensome. Strict compliance would render, because it would render the site pretty much unusable to any use, ground floor and second floor, because the ordinance requires a certain amount of parking that is off-site, that is on-site, off-street. So on the property, and not, it doesn't recognize the on-street parking that's a public entity. If this was within 500 feet of a municipal parking lot, and didn't cross Coolidge, then their parking is waived. They are just outside that zone. Also, the applicant had shared that she had sent out letters and really looked for a shared parking agreement within 500 feet, and no one was prepared to put something in writing. And they've she's also stated in her application that that requirement for 3 parking spaces per service chair is unreasonable due to their strict appointment policy only. And it could very well be when these zoning ordinance regulations were originally crafted, that's how most salons operated, is that you have somebody who's waiting, and you have somebody who's service, and then you have somebody who's going. And the applicant, I'm sure, will talk about how her model is different and for different reasons. Then the variance will not adversely impact the surrounding properties. And here, quite frankly, you're faced with a bit of a conundrum, is that absolutely, this could adversely impact nearby properties, especially those on the residential streets, and if parking is continually, parking continually happens on those residential streets. However, if the building at 320 Coolidge is for sale, and without a parking occupation of some sort, that building could remain vacant for an extended period of time. And vacant buildings can be a blighting influence, adversely impacting the surrounding properties, commercial and residential both. Finally, I just want to point out that the scope of the project doesn't include the space on the second floor. And eventually, that's going to come into play. These all might be larger issues that need to be solved with a zoning ordinance rewrite, but at this point in time, there is someone who is excited about purchasing this building, but is faced with a real difficulty in terms of parking, but the avenues for you to remediate that also might have adverse impacts on the surrounding properties. And so I'm happy to answer any questions and help with any technicalities.
Thank you, that's a lot, and we appreciate your due diligence and continued work to try to get us all the answers we need. Does anyone have any questions for Ms. Minock?
Yeah, I have a question. So the
Mr. Wilner?
variance they received originally for the parking, was that a use variance?
I think it was classified as a dimensional variance, because they just said, you just use the on-street. The use would be,
Because the use would run with the property then, so then,
well, in the dimensional variant, yeah, but then that use ceased, because you had the beauty salon,
Then the other company came in.
Then Spike Lawrence came
then
in.
Spike Lawrence came in, and then that. But I can see where you're going, and no, it wasn't a use variance, because that use was allowed in the zone. It was a dimensional variance to waive the parking.
okay. That is it.
I do have a
Ms. Ward?
question. What has Spike Lawrence done in order to handle their customers? I know they don't have a large amount of customers, but how have they handled their parking situation?
We don't have any records of that, except the indication on a list that that property was part of a shared parking agreement. Spike Lawrence, so at 320, 310 Coolidge, and then the Vibe Credit Union to the north. However, I looked today through multiple site plan folders for the Vibe Credit Union, looked through site plan folders for 310 as well. We didn't have anything for Spike Lawrence because it's been a continually reoccupied building. We also looked in the building files for all 3 properties, and we couldn't find a shared parking agreement or anything that documented how any of the sites would deal with the parking. I know Vibe Credit Union, however, was before you before for parking variance, which eventually they pulled because there was a change in the zoning ordinance that the planning commission could handle that at site plan.
Right.
Yes.
Was there any correspondence from Vibe Credit Union regarding this?
No.
Okay.
There was correspondence from someone who lives adjacent to Ms. Valensky and
Okay.
Mr. and Mrs. Valensky, who live, their property line abuts the rear of the Vibe Credit Union, their side property
Okay.
line.
And we have that letter in our
in your
their
packets.
package. Yeah.
Any other questions? If not, I will call on the petitioner. If you could please come forward, state your name and your address, and then just share with us a little bit about what you're doing and why you think we should approve the parking variances you've requested, please.
Okay, should I state my home address?
Yes, yes.
Okay. Okay, good evening, everyone. My name is Takesha DuBose. My home address is 20038 Oxley Street. That's in Detroit, 48235. And just to get started, you said to state pretty much what my business offers and why you should consider approving the zoning ordinance. What I offer as a business, I actually offer a small day spa and salon. I have 3 employees, including myself, and we offer holistic services to clients. And what we do is we take each client by appointment only. So we don't have a lot of traffic at one time. So what we usually do is we'll schedule appointments within 2 hours of each service. So that's what we usually do. So it's usually quiet, but we do have cars for we need parking for the employees, which we're willing to find city parking where we can park and we can walk. So that's something that will not be a problem for the employees. I think that the ordinance should be approved because I feel that it will also not just help my business, but also be an asset to the city. Because as we talked about, in order for anyone to purchase the building, there has to be some sort of parking agreement. I myself have been looking in Berkley for a space for maybe about 10 years. So when this building came up, this was definitely, this was definitely an opportunity for me. I'm sorry. Don't usually do a lot of public speaking.
Oh, you're doing
so
just fine.
I apologize if my voice sounds a little shaky. However, as I stated, I think that it would be an asset to the city because of the type of services that we offer. It would be an asset to the neighborhood. It's someplace that you would be able to walk and come to not just receive services, but we carry a lot of vitamins, holistic products. We offer books on health and different things like that. So I do feel that this would be something that would honestly kind of incorporate what I see when I drive through Berkley, which I'm here all the time. I shop here. I'm at Westbourne. I think that, as I said, my business would definitely fit right in with what I see going on in the Berkley area. It's always nice, quiet, clean here. And that's sort of, the ideal that I would be bringing here as well. Again, in order for this building to sell, there would need to be a parking ordinance. Give me a second. Okay, so I feel that, like I said, we would be an asset because of what we offer. And again, about the parking, it has to be parking. And I think I'm going to end right there because I'm kind of getting stuck and it's not going well.
Sure, you did fine. Thank you very
Okay,
much.
thank you so much.
Oh, I'm sorry. We need to see does anyone have any questions for the petitioner? So I don't know if you want to come back.
I just have one question.
Okay.
Definitely answer questions.
I was just wondering about, I know might not be a definite plan, but what are your thoughts on the second floor?
On the second floor, I don't have a definite plan, but I have been throwing around ideals, and I know that I would like to finish it. Right now, It looks like at one time it could have been like a residential space where someone actually, maybe a living space. So that is something that I'm considering. And of course, that would be for one resident only. I would just finish it out as one open space, sort of the way that it is now, just, remodel. So that was my consideration for that, not to use it as a part of my business.
Yes, Ms. Sarah?
Did you say your appointments are 2 hours each, or how do they run?
Usually it's anywhere from 2 to 3 hours. Sometimes they can even run into 4 hours because we do offer multiple services. And myself, I do multiple services. So sometimes I can have a client that comes in for hair, a manicure, a pedicure. So then that would almost run into 3.5 to 4 hours for an appointment.
What would be the shortest amount of time you would see someone?
Usually maybe an hour and 15 minutes, and that would be someone that may come in just for a manicure only.
Any other questions? So where's your business currently located?
I am currently located in the city of Detroit. I'm in a little area that was kind of brought to the neighborhood maybe about 7 years ago on James Cousin Avenue.
Okay.
So that's where I'm currently at. I've been there for 7 years. Before that, I was in a space in downtown Detroit. And I was there for 8 years.
So how many customers do you potentially see in a day?
I potentially, just myself, I see anywhere from 5, maybe 4 to 6 clients, depending upon the service. But 6 would be the max.
And then you said you had 2 other employees, so is there a time where all 3 of you are in the building all seeing a client? So there would be potentially 6 people between you 3 and there are 3 clients.
6 people for the entire day. But the way that we work now, we usually don't see one another because everyone has their own work schedule. We all sort of work almost like a part-time schedule. I work, like today, I worked on Monday. It was just myself working today.
Are there set hours that you're planning on having for the business then? Or is it kind of vary on who's working and who the clients are?
Well, that's the way we do it now. I would like to have set hours because I just think that that is professional. But although I have set hours, we still individually know who our clients are right now, and we kind of take them within that time frame. So it may be 9 a.m. to 6 p.m. every day are the hours that we would take clients in between those hours. So it doesn't always mean that we'll work from 9 a.m. to 6 p.m., but that's just the time frames that we give to offer our clients.
I mean, sometimes is it off hours, like, 7 to 9 a.m. or 6 to 10 p.m. or anything like that?
Well, no, we don't generally do business after 6. However, I will schedule clients before 9 a.m. for certain services. Like I will start at 7 a.m. on some days, but that's not generally the hours that we offer.
Okay. Saturdays and Sundays, or?
I will not be opening on Sundays, but it will be open on Saturday. I do not work on Saturdays.
So if you get a client that comes in or is scheduled for 5:30 and is doing a 4-hour service, are you there till 10 p.m. or you don't schedule a 4-hour service for that late in the day?
We don't schedule 4-hour services at 5:30.
Okay.
Yeah. So the only service that could be scheduled at 5:30 would possibly be a manicure. Yeah, because then we could end the day, around 6:30, and then you clean up, and then you are kind of out. But yeah, we don't work after dark. Yeah, so we generally close up around 6. And to be honest with you, myself, I generally end my day at like 3 o'clock.
Ms. Ward?
Yes, Mr. Boyce, do you provide massages?
Well, not at our current location, but I have provided massages, and that is something that I would like to offer,
And facials?
and facials. We do provide facials now.
Oh, you do?
Yes.
Okay. Thank you.
Thank you.
Are there any other questions for the petitioner? All right, thank you very much. So we will move on to see if there is anyone from the public who wishes to speak. So we'll have you sit down for now, and if we need you, we'll call you back up.
Okay,
Thank
thank
you.
you.
So now if there is anyone from the public who wishes to come up, if they would just please come to the podium, state their name and address for the record, and their thoughts on the petition as it's been presented.
Hello, good evening. I said I wasn't going to do this, but with the information that we're receiving this evening, I have questions. First question up is in regard to what Ms.
Ma'am? Oh, I'm sorry, we need your name and address for the
Okay,
record.
I'm sorry.
That's okay.
I'm Denise Folensky. I'm the one who put a letter in your packet.
Yep.
Yes.
Dan Folensky, the other property owner, is also here as well. We both went in and talked to Kim Anderson at length and got information about this situation. Then had an at-length conversation I did with Megan. I would like to also compliment her on her packet. She was very thorough. I think she tried to hold both sides of the fence on this and be fair to everyone. However, when we went into the office and spoke to Kim Anderson, she specifically mentioned that the hours of operation for this business would be 9 a.m. to 9 p.m. When I spoke to Megan, she was unclear about that, but she did verify that the days of the week would be Monday through Saturday. So we got a little bit of conflicting information on hours of operation. Hearing what Ms. DuBose has said tonight about her possible hours, I am still a little bit concerned about that, considering that my property is right next door to the Vibe Credit Union. Wasn't going to bring up the Vibe Credit Union tonight, but because we are kind of being pulled into this, I've lived on the property for 45 years. 5 years into living on our property in our new home, 2 houses were torn down, and Vibe Credit Union came to visit me and my former husband. While it isn't a Burger King, as City Council tried to tell us we should feel fortunate for, we have had our share of problems over the years with various members of Vibe Credit Union, including current situations that are outstanding since the renovation process took place 2020 to 2021, which was basically last year. A lot of things we weren't told, a lot of big surprises that came with that renovation. Myself and the surrounding neighbors, because I've talked to a couple, felt very upset, for lack of a better word, that we weren't given more information in regards to what was really going to take place with that full renovation at Vibe Credit Union. As far as I can recall and have observed over the years that I've lived in our property, for as long as Vibe Credit Union has been around, it seemed to be verbal. I don't know what the agreement was, but they were sharing parking with what was Cut and Curl, the youth hostel, the nail shop, and now the current owner. And we did our due diligence, like it or not, with the renovation. And we know for a fact that Vibe reduced their parking with this last go-around. They thought they had good reason. They got approval to do that. And as a result, we recently noticed that there's a sign on the wall that is on that side of the property. There is also a sign on the pole that is on that side of the property that says members only. So I'm a little bit confused tonight as to whether Ms. DuBose is going to be able to get Vibe approval for parking, and I'm presuming she would like to have, or they would like to offer the spaces that are right alongside of the Spike Lawrence building. Because we're basically getting two different bits of information on whether that parking is for members only, and as I said, it's posted, or whether they're going to be kind neighbors and cut a deal with her basically to share that parking. My biggest concern, and you've seen it in the letter that we submitted, was any lack of parking, and Megan mentioned kind of two different things tonight, that initially, supposedly Ms. DuBose took a 500 square foot circle and asked all of her surrounding business neighbors if they would share parking, and no one said they would. That's what we discussed in our conversation. Then I looked through the whole packet and found out that in Ms. DuBose's paperwork, she said she did have permission from surrounding businesses. If surrounding businesses are going to share with her, that would relieve me as a neighbor, especially having survived the challenges that we have with Vibe and continue to survive. But there's no guarantee on that. And that's my concern. Again, I'm sorry, I don't remember if I said, we were told by Kim Anderson, the building clerk, that hours of operation were gonna be 9 to 9. Ms. DuBose just said she doesn't work after dark, but I would like to dispute that in terms of the fact that in the wintertime, it's gonna get dark, 5:30, 6 o'clock. So anything beyond 6, they would be working in the dark. Maybe insignificant, but my major concern is that if this variance is granted, and number one, you've read the packet, I've read the packet. This is history repeating itself. If you read your packet thoroughly and read the extensive information from Ron Meyer, you will see that he's been, or was, put through a lot in years past, and it just looks to me like if this variance is put through, we may be going through the same thing all over again. What's questionable is whether it's going to be the business owners only that may be challenged by this, or if it will filter into the neighborhood, which, as I said in my packet, is Earlmont and Edgewood. And frankly, I have enough with what's been going on with Vibe that I would prefer not to have any additional parking landing in front of my house. And as I stated in the letter, my side of the street is a fire lane. But that doesn't stop people from parking on that side of the street if they choose, and they have, and I frankly don't want to be put in the position of possibly having to police that. So I would ask, this gentleman asked what her hours of operation would be. I feel like she kind of skirted around that issue. And again, my biggest concern is, having lived next to Vibe and having been through as much as I have as a property owner, promises, outright lies, things that are not followed through on, and then they do as they please regardless, and this has been over 40 years. Anything could be stated in terms of what the hopes are, and then once the business has been purchased, we may be dealing with a whole different ballgame. So I would like to just question and ask you to please maybe pin her down a little more on her hours of operation. Other than that, I can't think of anything else at this point, so thanks for listening.
Okay. Is there anyone else in attendance at the meeting from the public who wishes to speak on this matter?
Madam Chair, I have a question. Is Gary Imhoff here? Yes. The property owner?
Yes, I am Gary Imhoff, and I currently own
But
the
I think-
building.
Wait, I think we're in the middle of the public, so do we
Oh.
want, yeah, I think we have to hold off.
Oh, okay, even though he's the owner of the property?
Yeah, because we're just taking comments from, or feedback from the public at this point
Okay,
is what this
all right.
purpose is, so.
'Cause I
So
would
I,
like to hear
I
from
do
him.
think it's important that we do read your letter into the record, so I'm going to go ahead and do that. So it was dated May 5th, 2020, to the city, 2022, I'm so sorry. To the City of Berkeley Zoning Board members, we request that the Zoning Board of Appeals uphold the intent of the ordinance requiring on-site parking for this proposed business, allowing a variance to encourage on-street parking for the employees and potential customers could bring congestion and noise along the residential streets of Earlmont and Edgewood. We believe that the business district should remain the business district on Coolidge and not be allowed to regularly filter into the surrounding residential streets. In this case, that would include, but not be limited to, Earlmont and Edgewood. They are the two closest side streets located near 3020 Coolidge to rely on for the on-street parking if the Berkeley City Code is in question is waived. The parking on Earlmont is currently restricted to the north side of the street. The south side of Earlmont is a designated fire lane. The possibility of any unknowing customers parking in the fire lane on Earlmont could be problematic. The residents already utilizing the limited parking will be further hampered by the potential additional vehicles that this proposed business may bring to Earlmont. Even though Edgewood could support parking on both sides of the street, it has a median running throughout that street. That could make regular employee and/or clientele parking on Edgewood problematic for the residents there as well. We were informed by the City of Berkeley employees that the applicant has indicated that she plans to have 3 employees, including herself. The applicant has indicated that her hours of operation will be Monday through Saturday, 9 a.m. to 9 p.m. The applicant has indicated that she plans to take clientele by appointment only, no walk-in clients. The applicant has indicated that she plans to instruct her clientele regarding parking restrictions. The applicant has indicated that she has no current plans for the second floor of the building. However, any of her indications could change at any time, requiring the probable need for even more parking. There is no reassurance that any instruction, either by the applicant or the City of Berkeley, regarding parking restrictions will be adhered to or enforced if the current Berkeley City Code is waived. And it is signed from Denise and Daniel Felinsky. And then we do have a letter from Dennis Hennanen, who, while most of you may know him as a member of the city council, actually resides within 300 feet of this property. And he is attending a city council budget work session this evening, or else he would be sharing his specific observations as a resident and not a city council member. He did state that he did not need to have his notes read into the record, but I think we probably will, I'll go ahead and do that anyways. So it's dated on May 9th. I kind of summarized the first part, but on-street parking during neighborhood walks and when driving on Coolidge, my wife Jennifer and I regularly observe 1 or more cars on the on-street parking in front of and around 3020 Coolidge. We have never seen retail activity at this property on those occasions. We've walked past during normal business hours. Future property owners could change the terms, and this is regarding a shared parking agreement, of unwritten shared parking agreements, and thus they should not be relied upon. Care should be taken that the use of shared spots does not leave the sharing property owner short of sufficient parking. See Berkley Code of Ordinances, Section 138-218. Under normal circumstances, parking that crosses Coolidge is not permitted. The city's past practices has been interpreted to include this for shared parking agreements. See Berkley Code of Ordinances, Section 138-22, C1A. Required off-street for non-residential uses shall be within the same lot or within 500 feet of the building, or use it as intended to serve measured without crossing Coolidge Highway. However, it is within the powers of the ZBA to disregard this provision with the proper findings of fact, and if it is necessary, to provide the applicant justice. Regarding enforcement of conditions, I believe enforcement of a condition that all customer visits would be by appointment only would be difficult for the city to enforce. I personally have looked into such conditions for a home-based occupation ordinance I am considering for the city, and I believe it to be impractical. I believe enforcement of a condition that all customers' employees be given directions on where to park would be difficult for the city to enforce, and I would believe it would be nearly impossible to enforce whether these instructions are heeded. Recall that any such conditions would run with the property forever and thus would require perpetual enforcement by the city for decades to come and would be a requirement for all future similar uses of the building. The need for the variance is not the result of actions of the property owner or previous property owners. For me, this is key. When the parking for 3020 Coolidge was severed from the property in relation to where the city's public parking on Edgewood was removed. If the parking was severed before the municipal parking was removed, it could be reasonable for the property owner to have assumed that the municipal parking would remain available indefinitely and to rely upon it for their business. If the parking was severed after the municipal parking no longer existed on Edgewood, then I believe it is a self-created circumstance and this variance cannot be granted. This information may be difficult but not impossible to locate. Information on when the property was split should be available at the Oakland County Clerk's office. If the city does not have information on when the municipal parking was removed, the Berkley Historical Committee may have that information. This is a challenging case between allowing redevelopment of an underused property and the remaining harmonious with the surrounding businesses, residential district, and zoning law. We wish you well in reaching your decision. Sincerely, Dennis Hennenan and Jennifer Hennenan. And they are residents at 2411 Earlmont in Berkeley. So that is all we have from the public. Since we have no one else and we have no other comments to read, we will close that portion of the public hearing, and I will reopen it back to my fellow commissioners for discussion and review. Ms. Ward, I think you had a question, so I will call on you.
Yes, thank you. I was wondering if the owner of the property was here.
Yes.
I have a couple of questions for you.
So if you could come forward once again, state your name and address for the record, and then we will go ahead and hear Ms. Ward's questions.
Yes, my name is Gary Imhoff. The address is 3020 Coolidge Highway in Berkley, Michigan.
Okay.
Your business address and your home address are the same?
I'm sorry. No, actually, I'm in Commerce Township, 8583 MNC in Commerce.
How were you able to market this property to Spike Lawrence in 2008? Were you the property owner at that time?
Yes, I was.
And how did you market the property at that time when there was no parking that went with the building?
I believe there was parking on Edgewood, but it was parallel parking. And then they put a berm or something in there and took those spots out right after I bought it, I believe. But I didn't realize there was a requirement for parking. And I don't believe we've ever had any problems in the last 13, 14 years with parking. But at the time, I never had any problem, and I didn't even consider it as being a problem.
The other question I have, what was the second floor of the building used for previously?
Well, we sell awards and plaques, trophies. So upstairs we had our assembly operations. So we might sell 400 or 500 plaques. We would set up a little assembly line and put the plaques and awards together up there, as well as there was a lot of component parts that we had to store up there.
So you're Spike Lawrence, in other words?
Yes.
Okay. What is your customer traffic like for your business?
Well, usually it's someone would come in, not necessarily an appointment all the time, but they would come in and maybe it'd take a half hour for them to select. We have a little showroom there, and they would select their awards. We'd write up the awards in typically a half hour. And maybe
And they would
not
park
more.
in front of the building?
Yes.
Okay.
Yes. And I don't believe we ever had any problem with parking. And actually, when I bought the building, it was 2 separate buildings. I believe it was a nail salon and a American Youth Hostel. So we took the wall out that separated it. So instead of 2 businesses, we just made it into one in the building. So since we had that much parking for one business, I think that was the reason we never had any problem with parking. Because instead of 2 businesses, it was just one.
And where do you park now?
I park right in front of the building.
You do?
which,
Okay.
You know, they had said I could park at Vibe, but I never really had any problem with parking, so I generally park right there. But I am a member of Vibe. I mean, I do their name badges, and I have an account there. But
Okay.
I guess I could park there, but I typically don't because we just don't. You know, it never seems to be a problem with parking. If it did, I probably would park farther down.
Did you have an agreement with Vibe that your customers, you and your customers, could park there?
I don't believe it was my customers. They just said I could park there if I wanted to.
Okay,
But I
and
think
it was
all
a handshake?
verbal. Yeah, I think it was. And we had an account there, and I was doing business with them, and so I don't believe we had any written agreement.
Just out of curiosity, where is Spike Lawrence going?
I don't know. I'm going to rent something or lease something, but I haven't decided yet. And I've been there 42 years, and
Well, I've used your services. That's
have you?
why I'm curious where
Oh.
you're going.
yeah, somewhere probably in the area because I do have a lot of customers in the area, and I'd like to keep it. But we incurred a lot of costs with the pandemic and everything, so I thought if I could liquidate the building, I could lease a building and use those assets to build it up a little bit again.
Thank you.
I actually had a question for
Guzan?
Mr.
Sure.
Imhoff. I'm actually a member of the Vibe Credit Union. Is that your truck?
Yes,
Yeah.
that old truck.
I have a hard time getting out of Vibe
Because of
Oh,
because of the truck.
is it too close
there.
to the sign? You mean?
It's
Yeah,
too
that's-
close to the exit of they moved the exit of the credit union,
Okay.
and it's
oh.
hard to see southbound
Oh.
with your
okay.
truck there.
Oh. All right. Well, I can park farther back, I guess.
Mr. Ular?
My question would be, what are your current hours and how many employees do you have?
We just have 3 of us there, and we're open 9. Well, the business is open to the public, I guess, from 10 to 4. We generally work from 9 to 5,
Monday through
Monday through Friday.
no Saturdays?
I do come in on Saturdays on appointment only,
Okay.
and I generally do, but I don't have an open. It's only appointment only on Saturdays.
Sometimes you have 3 employees working there at one time?
Yeah. Yes.
Where do they park?
They park in front as well, but I only have 2 cars.
Okay, and that's never been an issue,
No,
so far as you know?
no. And we've been there about, I guess, 14 years.
Thanks.
Okay.
Thank you.
Any other questions? Okay. Any other, thank you very much.
Okay.
So, at this point now, we need to, review the information that has been presented, and determine how we want to proceed. I don't know if there's any other questions for, whether it be the petitioner, Ms. Minoff, at this point, so we can entertain those.
I have one more question for
Yes, Mr.
staff.
Ular?
I guess I was trying to follow the presentation. I want to make sure I know as best I can, the answer to the question Dennis, Mr. Hennon is asking in this letter, specifically on the second page, the two paragraphs where he says, if the parking was severed before the municipal parking was removed, or if the parking was severed after the municipal parking no longer existed on Edgewood. Do we know which one of those
Yeah.
to be
So
true?
the parking was removed on Edgewood in 1999. The city vacated that portion and sold it to 310 Coolidge. So that was 1999. In 2015, that's when the back of 310 was severed, combined with the parking lot that to the rear, and that L, making kind of an L that connects back to 310. So that's when 320, in 2015, 320 went from an 80-foot deep lot to a 51-foot deep lot. And that was well after the parking on Edgewood was vacated in 1999. So if you used Mr. Hennon's rubric, according to him,
It was severed after.
it was severed after, and it was self-created so
was
that
no-
you
Okay.
couldn't, his opinion would be that the variance shouldn't be granted.
I thought I was getting that, but I was kind of confused.
It's definitely a catacomb of policy.
And then I guess my next question would be, is there any sort of business, you might have already answered this, that would not need a variance?
No. Every single business is required some sort of parking.
And there'd be nothing wrong hypothetically with a business with much more foot traffic to try to buy that building? Or, right, I mean,
Yeah, or also the second floor, I'm not sure how big it is, but it could probably be converted to 2 or 3 dwelling units. So,
The building itself has a lot of potential for foot traffic.
yes,
In this proposed
yeah. And
use, it's not as much as it potentially could be.
and something that could generate more foot traffic and also have parking stay for longer and more turnover is something that would be a restaurant or a bar. Those tend to have a long period of time. Also, but one thing that is unique about Berkeley's downtown as opposed to some other places is that you don't have metered parking. So somebody can park all day on street, whereas if you were in a situation where there was signed parking and it was enforced, or there was metered parking, then that makes that on-street parking not a viable option for employees to be able to park there all day. So,
And if I can interject, back in 1999, when they severed the parking and sold it off, Berkeley did have metered parking, which would have kind of justified
still,
them
no
getting
matter
rid of the
what,
parking.
long story short is no matter what, this building doesn't have any parking associated with it, and the zoning ordinance requires that. If you wanted to limit the impact of traffic, foot traffic for this particular use or for the building, you can also place conditions on any variance as you have before, and
enforcement.
Yeah.
Yeah, but who's going to enforce it?
So hypothetically speaking, if we grant this variance and the building is then sold to somebody who wants to put a bar or restaurant in it,
then if you put conditions on the waiver of the parking, it would only be for, they could only, let's say you said hours of operation have to be 9 to 6, as the
Okay.
applicant said, then that goes along with it.
Okay.
That condition runs with the land with the variance as well. And in my letter, I had recommended that you, at least if you're considering granting the variance, having conditions that stipulate things that at least the applicant has offered, like the bike racks, like the hours of operation, like the by appointment only. So, and the other thing I wanted to say is that the applicant had said that she had been given verbal agreements, not written agreements on parking. And, I mean, I think we demonstrated today that we had evidence that there was a written agreement, but if it's not codified by it being attached to the property in some way, then it's very hard to enforce, and things get lost over time.
And someone can change that.
Madam Chair,
Yes, Ms. Ward?
do you think you can find the agreement?
I have no idea. I mean, we looked before, when Mr. Boyce came in, I pulled the building file, I went all the way through it. And Ms. Anderson helped as well. That's when we found the zoning, that's when we found the variance that was granted. We consulted with the city attorney, and then he gave us the opinion that variance no longer applied. Then, you know, I had pulled all of the files that we had for Vibe Credit Union.
We try asking Vibe?
We could try asking Vibe,
Even the
but,
property owner though says he doesn't have, there's
Right.
no.
Yeah, he
So,
doesn't have an
I mean,
agreement.
we
Yeah.
could, we could research it, we could ask. I have no idea whether a parking agreement that is valid and enforceable would turn up or not.
Yeah, I don't know.
Can we ask who she said, I mean, she got a verbal agreement or a verbal approval from who? Or it doesn't matter.
I think, I mean, yeah.
Yes, please.
Okay. Your question is about the verbal agreements?
Yeah.
We received a verbal agreement from the VFW Hall, and that's directly across the street from Spike Lawrence. And Vibe Credit Union also gave us a verbal agreement, but they are not willing to put an agreement in writing.
Who was it that gave you was it the branch manager?
The branch manager, yes. But she also stated that she doesn't feel that we may be able to get a written agreement because that would have to actually come from the branch. Like
would
the
have to come from the
administration or the
headquarters.
headquarters,
Yeah.
yes, yes. And may I also add something to the record? I did hear the concerns here today, and I would just like to state that the service and the business that I'm offering, this has been something that I have been doing since 2002. So this isn't a concept that I just created today. I have always operated my service in a private setting with one person at a time because my business is more geared towards relaxation and holistic care. So it's not your typical salon or nail salon where you have the flow of traffic constantly. What we like to offer, as I said, is a service more geared toward relaxation. So it's more of a therapy. It's not the typical place where you just take walk-ins and there's constant salon habits going on, where we offer jazz music, so it's very quiet. And that's more of what our service is about. So this is something that I have been operating and doing for, like I said, since 2002. And I didn't have my own space in 2002, but this is always the way that I've done my services. So as far as the parking is concerned, on the residential streets, that would never happen because I'm also part of a community, and that's very important to me to function, ethically and correctly. So, as I said, where I'm operating now, I usually leave work no later than 3 p.m. but you want to offer your clients a variety. You can't actually purchase a building and only offer services from 9 a.m. to 3 p.m. You have to give that option. But because I have the same clients that have been with me since I've been in business, and also the 2 other young ladies that work with me, we've been working together since 2006. So one of the young ladies, she still works for one of the cities in Michigan. So she has a full-time job. So like I said, we operate on a part-time. So we won't be in the salon, night and day like some salons are. You can drive by and people are still there at 10 p.m. That is not something that we typically do or that I wish to do now or in the future. Okay, thank you.
Any other comments or questions? Ms. Ward?
Well, as my brain is rotating here, if there's a possibility of finding this elusive agreement, would it be in our best interest to table this issue and bring it back next month? Or is the fact that there probably isn't this agreement, or it is wishful thinking or whatever?
If you chose to table, we would definitely do some more research and look. I think that, I don't know what, I think you might want to ask the applicant and the property owner what their agreement is in terms of, and what their timeframes are. I know that you've asked that before. We would definitely look at, and we didn't have a chance to talk to the clerk, but I can't give you odds either way as to whether it would be found.
So I do have a question. So if we are able to find the shared parking agreement, how does that parking agreement play into the fact that Vibe has had a reduction in their parking spaces as well?
We would have to look at whatever that parking agreement was, when it was signed, what the conditions were. The other thing that you could ask us to look into and ask the applicant to look into is that you could indicate you were willing to waive or give a variance about the crossing of Coolidge, because currently what the ordinance says,
Because you can't do that.
which I have never seen in any other ordinance for a downtown setting, is that parking can't be crossing a major street, either, i.e. Coolidge or 12 Mile.
And we had a similar situation, I don't know if anyone remembers, with chemical.
Kipling and 12
With the
Mile.
chemical salon, they were going to be able to share parking with Rite Aid, but we did not count that either because it was the crossing of 12 Mile.
Right, so you could waive that crossing of Coolidge if you wanted to.
Is there municipal parking across?
No, but if they had an agreement, if they had a written agreement with VFW, then that would be something that the ordinance would recognize. So you could ask the applicant to explore that more. The VFW is a redevelopment, probably a redevelopment site. So as staff, if I was sitting in the seat, I would want to see a written agreement that was recorded with the county, so that whatever use or redevelopment comes to that area, they know that they made that commitment to that building. And I think it would be appropriate for a ground floor retail use. I don't think that shared parking would be appropriate across the street for an upper story residential use.
So in that particular case, if there were 3 spots hypothetically that they were gonna take, but whoever came in and redeveloped that, they would have to then, those 3 spaces would not count for their parking.
Right, they would encumber their site. So let's say you waive, the applicant we're gonna take a hypothetical. Applicant goes back and talks to VFW, and they get, say that we'll do shared parking, and we will designate their shared parking spaces, for up to 7 spaces for you, because the ordinance requires them to have 9, and they say that they'll put in a bike rack. Then all you're waiving is that, all you're
Crossing
waiving
of the
is the
major
crossing of
street.
the street.
Yeah.
Which, so,
But fast forward, they then are 7 less.
they have 7 less parking
Yes,
spaces.
right, right.
Yeah.
I mean,
For whatever requirement there is at that time.
right, whatever they plan to build. So,
Just like if there's a shared parking agreement with Vibe, Vibe already has a
Fewer
parking problem,
Yeah, fewer parking.
which is why they can't really do shared parking with,
right, we already reduced,
Yeah.
well, we did not, but the number
Yeah.
of parking spots Vibe required was reduced.
right?
Essentially, we have a building that can't be used by any business and be in conformance by anyone, so it's
Yeah, and somehow the city allowed that to happen. I mean, that's, you know, I
yeah.
guess somebody must have sold, it's just, yeah, it's like a little island that'd be floating there meaningless if we, and I don't think we can, to make it incumbent on whoever gets that business to have to go find a shared parking agreement. What if everybody just says no? I mean, then it's just gonna be a useless building sitting there?
In that example, if I was the VFW, I'd say, okay, and then I'd be like, oh, wait a minute,
And I think
I
that's,
can't then put in any number of things because when I go to sell, no one, they have 7 less spots. Which means the building becomes this or.
I mean, they could give up 3 spots, and we would have to give a variance of
Right,
allowing
right, but I'm
3
just saying,
in.
but whatever,
But yeah, I mean, 7's a lot to give
but
up.
you have had testimony from the current property owner and business operator describing their operations and how many people are there and how many customers there are at the same time. And with the situation that they're using.
That's the thing to me, same number of employees, pretty much the same hours or close to it. I mean, those hours were a little less, granted, what he said. But it's the same number of employees and generally 9 to 5 business. We're substituting in another one that's gonna have a little extended hours and some Saturday time, but
They don't have the clientele that Ms. Du Bois would have. They have clients really spread out.
well, what I'm saying, yeah, but I've never been into the current location, I'll say that right now, but my understanding is anybody could walk in at any time. Like, if I'm gonna go buy a plaque or a little whatever, you just walk in maybe.
Name tag.
Yeah, name tag.
Name tags.
I don't think that's gonna happen as much at the salon, right?
Right.
So-
Their business is, a lot is done by phone. Mr. Imhoff, if I'm correct, a lot of your business is done by phone. Yeah. And so they don't have, and I'm assuming that you mail out some of the trophies or the plaques, so people don't have to come to the shop in order to pick up, whatever.
I guess my point is, it's not like you're sticking, the green lantern there or something. It seems like they're fairly comparable kind of business-type footprints.
Well, if you remember with the Green Lantern, their owner swore to us, standing right there, that yes, he had talked to Country Kitchen, he had talked to the veterinary hospital, and he had talked to the people that owned what used to be the doll hospital. And they all verbally said he could park. Well, then, when we went back, and I happened to go into Country Kitchen and I asked them, they said, oh, we told him absolutely not, because we barely have enough parking for our own customers, especially at dinner time. And so,
I wasn't bringing that up as an example of,
But unless
parking
it's in
variance. It's just
writing.
that business is, a
Yeah.
really busy bar, restaurant. We're not
yeah.
Yeah, if it's
sticking
not in
that.
writing, essentially, yes.
Yeah, if it's not in writing, to me, a handshake and a
You could tell
wink.
your customers, don't park on the street. You can't control where they park. I mean, Yes, I agree, maybe she feels that way, and she's gonna tell them, but yes, unless something's not right, you can't.
But you can't control it, no.
But again, we have a business then that it can't be used.
Well, it needs to be a business similar to Spike Lawrence, where you have a lot less foot traffic. You don't have the clientele stopping by. It's a situation where it's limited. We take a look up at, Wilshire and Woodward. There is such a small amount of parking that they haven't been able to rent that building in 4.5, 5 years. That used to be the Coffee Beanery, and they haven't been able to rent that because there's not enough parking. And they do have a parking lot.
I guess I have one question, Mr. Boyce. So at any given time, though, if all three of you were servicing a client at the same time, and you each had a client, there potentially would be the need for 6 cars to park. Is that right? I mean,
Yeah.
Yes, that is correct, if that were to happen. Yes.
But you've also represented that you and your employees would park in municipal
Yes,
parking.
we would be willing to walk from wherever there is public parking. I mean, because where I'm at now, we do have a parking lot, but we typically park further away than the clients. So wherever there is public parking, which that part I haven't really discovered, I would be willing to walk. So that way
Write it.
we're not taking up 3 parking spaces.
You could make that a condition of approval. Again, it's hard to enforce.
right, but where is the closest public
So
parking?
the closest parking probably would be down by where Sugar Kisses used to be. There's parking behind there. That might get more traffic. Also, if you move north, the parking lot that's just across the street here at City Hall, which
That's a long walk,
I come here-
especially in winter.
I come here all the time, and it's rarely full. There might be some days though.
Sugar
that it
Kisses as well.
So, I think there's some public parking. I don't know that there's public parking on the other side of Coolidge anywhere nearby. But I think you probably, I would recommend at this point in time, moving towards a motion, whether it be to table
Sorry.
or approve.
I'm sorry, you guys are sitting here this long.
Yeah. Because it sounds like that's the sentiment. You have one or the other.
Yeah.
Do you think you could get something in writing from the VFW?
I'm not sure because honestly, I believe, if I'm not mistaken, because my real estate agent has been working with me as well, I believe they may have a written parking agreement with someone, and that's why he wasn't willing to do it.
Oh, they already have one in
They
place.
may, I believe that's the reason with the VFW. You know, and we did also speak with Bagger Dave's, but again, with that being a restaurant,
Yeah.
they can't guarantee it because they might need their own parking. So, yeah, that has been the situation. Yes,
Can I ask
ma'am.
one other quick question? Is there any potential that you could have more employees there? Or is 3 the maximum that you would, including yourself, the maximum you would have?
Yes, 3 would be the maximum because that's what the business license would state. And I'm sure as you get the plans drawn up and the city comes out to approve you, that's what you're approved for.
Okay.
But that's what I have now, and that's the way I've been working, like I said, for many years. So I don't see that changing because as you guys can see, I'm sort of the type of person that likes to be in a calm environment and just with a lot less people. That's how I work best. And that's why I would like to have a small space where I can just work with a few people, continue to do this until my hands tell me that I can't, and keep it very calm to the point where I can do 4 people per day. And like I said, I'm probably working a good 3 to 4 days. So I'm not there on Saturdays. Honestly, there's only one girl that's working with me now that comes in on Saturdays. And she's usually out of there by 1 p.m. So we all have families, and we don't spend our time confined to a salon spa.
What's the timing on the sale? Like, is there you have a 30-day close?
Well, yeah, it's been kind of extended because of the parking. So we have been trying to come to a solution with the parking, and that's been the delay. Yes.
If we just need your name and address, so if you can come forward, please.
Come to the podium, please.
Good evening. Jeff Anderson, 4615 Robinwood Avenue. I'm the real estate agent for Gary Imhoff, the seller agent. The contract is through June 1st. So I just want, you asked how long the contract was for.
Thank you.
So, yep.
Ms. Ward?
I have some concerns too about the residents. We had Mr. and Mrs. Valinsky here, and the last thing I want to see is people parking on Edgewood or Earlmont. I think people might be more willing to try and park on Edgewood. But still in all, there is a possibility that people would park in the neighborhoods. And that was an issue with the Green Lantern project, that I did not wish to see folks parking in the neighborhood. People buy their house and they expect to have the security and the privacy of no one parking in front of their house except themselves. And the possibility that such a thing might happen, that clients from the salon might be willing to park on Edgewood, causes me some concern for the residents.
This is a this is a 3-employee salon by appointment only. I don't think you can have a vacant, decaying building on Coolidge indefinitely that is good for anybody, including the residents. And I'd also point out, and I said this with the Green Lantern, like, I live near Anderson Middle School. Like, if you live near busy areas of Berkley, I'm sorry, you gotta expect something goes with it. Like, I have football traffic, they just stuck a portable toilet in view of my front door, which is really great. But it kind of goes with the territory, right? If you're really close to Coolidge, there's going to be businesses there. Would somebody park there once in a while? I'm not going to say it's impossible, but in my view, it's an absurdity to go forward with a decaying building, and for us to just kind of punt on it is like, I think would be I mean, I can't, and you know, I certainly respect Dennis's opinion, but this is a, you know, kind of like the supreme definition of something that really needs it, right? You literally cannot have a viable business there without a variance. Like, this isn't like a generator or all these other things that come before us where, you know, really deep down, we all know somebody could live in a house if they don't have a mudroom or they don't have a generator or they don't have their big or whatever. This is like, you can't have a business there without it. So I think we gotta grant it, but that's just me. And I would think, like, you know, we could put hours, like 6, 7 p.m., something reasonable. I think we can put in that the employees can't park there. And that's kind of hard to monitor, but not entirely. Like, if somebody walked in and said to the owner or the person at the desk, "Where's your car right now?" I mean, if it was out in front, that'd be a problem for them. So those are just my thoughts.
Is there?
Coming in, I was, in thinking about it, I was more against it. Hearing the style of the appointments, the length, I don't think you're, even with three employees, you're not gonna have 3 or 4 people per employee either. You'll have one finishing up and one coming in, which I think is encouraging. And even You know, that's if it's an hour. I think, you know, if the appointments go a little longer, it will be less than what I originally expected it to be, and I find that a little more encouraging than what I originally thought it would be.
And through the site plan approval process, the plans would be reviewed. And for example, at Chemical Salon, I believe they came in front of us originally with 6 chairs. And we said, with 6 chairs, you need X number of parking spots. In this particular case, there would be a specific, she would be designing it to accommodate herself and her other 2 employees. So the interior design of the building would not be 6 chairs.
No, the interior design.
It could be, but the planning commission would then say that's not.
Let me clarify something. So this is, this would not go to the planning commission.
Okay.
Because they're not proposing to, she's proposing to do interior renovations and move in.
Okay.
And the use would not be more intense than what's there
Okay.
presently. The salon that you're mentioning, I'm not sure whether it was a new build.
It was the
But-
renovation of that, okay.
Or-
So that was probably the difference. It was a
Yeah, it
transfer,
was
okay,
a-
that was the difference, okay.
So that's probably what made them go to site plan. What would happen is if you passed it and there were conditions on the variance, then that would be referenced every time they pulled a building permit. Every time they had a business license, that would be part of their business license inspection. And so that's what goes along with it. And so that's the checks that you have as a city. But it would not go to an appointed body like the planning commission. You're the appointed body who would decide something, and then it would be enforced through the administration of building permits.
And then in 10 years, when she said, okay, I'm done doing this, whoever is the new business comes in for their business license as well?
They
or-
would come in for a business license, and people ask, you know, what's going on with the property. The city would tell them there was a variance, just like we found the variance when Ms. Du Bois first came in. We said, you know, this is what's attached to the property, these are the conditions. So if your conditions were no more than 3 employees, your operating hours are 9 to 6 p.m., and you have to have 2 bicycle racks, then 10 years from now, if she sold the building or was looking to have somebody else, she was gonna rent it and a new business was coming in to the ground floor, then those act like zoning, and those are attached to that property. And even if she's not the property anymore, the variance and the conditions of the variance run with the land.
So it could be no worse than what we could say yes to today.
Mm-hmm.
Or they would need to be coming back to get.
Right.
Okay.
I ask a quick question.
Yes, Mr. Wilner?
If the conditions, if the variance runs with the land, then why is the variance that was originally granted?
Because it was attached to a grandfathered use.
Okay.
And that was specific in the motion. And so,
All right, I'm having trouble. I
yeah,
keep going
no,
back to that.
I did too. And I thought it was very odd. And I will say the motion was very poorly written, in my opinion, and the city attorney agreed with me. But because of the way it was written and that it was associated and predicated on a grandfathered use that then ceased and was replaced by something else, then
Yeah, I mean, in my opinion, I agree. I agree that we have to maybe have conditions, but I think the building's not usable by anybody, so. No. I think we have to grant some sort of.
Okay, Ms. Ward, I think you had one more comment or question. If not, I think it's time we entertain a motion.
I forgot. I forgot my question.
Well, I'll give you a
well.
second, 2 seconds, 5
Nope.
seconds.
No, we're good.
Okay, then I think it's time we entertain a motion on the specific request. Application PBA 0422 at 3020 Coolidge Highway, a dimensional variance request to waive on-site parking requirements. I believe what we've discussed is we can either leave this vacant or we can come up with some conditions and make a motion to approve this such that We do not have a building that is sitting vacant for as long as it can be. Yeah, I was gonna say eternity, whatever we wanna say.
I'll move to
So close.
table this until the staff can do additional research for an agreement, a parking agreement with Vibe Credit and the VFW.
So, can I ask a clarification? Did you mean staff can do additional research to see if there is an existing?
Yes, because you alluded to that, that there may be a agreement that you weren't able to find this afternoon.
Okay, would you mind if it is that you move to table until staff can do additional research to see if there is an existing parking agreement for this property?
Yes, that would be fine.
All right, we have a motion. Is there a second?
I'll support.
Second by Gesund. All right. Madam Chair, would you like me to take a roll call?
Yes, please.
Gesund,
Yes.
Krug,
Yes.
McAlpine,
No.
Sarah,
No.
Euler,
No.
Ward,
Yes.
Wilner.
No.
Motion fails, 4-3.
I'll try and come up with a proposal if you guys will bear with me.
So you wanna make a motion?
Yes, to-
So should we discuss some possible conditions?
She could make a motion and then you
Okay,
could.
just wanna make sure we get them both together. Okay, so go
Okay.
ahead.
I propose that we approve the parking variance with the conditions that there are 2 bike racks at the location. The employees agree to park in municipal parking, and it pertains only to the ground floor portion of the building.
I would say that we add no more than 3 employees, including the owner of the business.
So,
And-
Ms. Sarah, are you friendly to his suggestion?
Yes, that's fine.
And what about the fact that the hours would run from 9 a.m. to 6 p.m.,
Monday through Friday.
Monday through Saturday. Yeah.
How about employees,
And by appointment only, yes.
employees park in the municipal
Parking
parking
area.
only during business hours? I assume she could park there before or after if she had to go in for something.
Clean, whatever, okay.
Yeah.
Do we wanna say specifically, something about services can only be provided between 9 AM and 6 PM?
Yeah.
Versus being open? Because let's say she were to take someone at 4:30, it's an hour and a half appointment, they get done at 6. That person potentially could go, but they still may need to clean up. They're not parking there, I'm just wondering if,
I didn't think we could condition the hours of operation. I thought we could condition like the parking hours probably, but
okay, I'm just,
So what it says is that it's anything that would be material to the, I can find it, but it's really that the condition then is needed in order to enforce the spirit of the ordinance. So I have seen hours of operation before. I think if you get into when they take appointments,
Yeah,
then you're
I was just
asking
giving
the
that
code
more of
enforcement.
as an example, not telling her she can't take it, but that, you know, the business truly operates, you know, closes for use. It's, I don't know how we would say that. Maybe that's not even necessary.
Oh, hours that are open to the public are 9 to 6. So do you want me to repeat back what I have as my list so far?
Sure.
Please.
Okay, so move to approve the parking variance that there are 2 bike racks, on the property. Employees park in the municipal parking lot during hours of operating hours. Operating hours are limited to from 9 AM to 6 PM, Monday through Saturday. The operation is by appointment only, and that no more than 3 employees, including the owner, can be on site with customers during operating hours.
And this applies to use on the first floor only, correct?
Correct.
Yes.
Okay. Applies to use on first floor only. So I've repeated the motion that was made by Ms. Sayre. Is there anyone who would support that?
I'll support.
Okay, Krug. Sayre. Madam Chair, is there more discussion, or would you
No,
like
I
to
think
take a
we're
vote?
good, correct? Everyone's happy with the conditions?
All right, Gazund,
Yes.
Krug,
Yes.
McAlpine,
Yes.
Sayre,
Yes.
Euler,
Yes.
Ward,
No.
Wilner.
Yes.
Motion passes 6-1.
All right, so do you understand what we just did? Okay. Good luck. Okay, next up is application PBA 0522. It is the property at 28105 Woodward. They are requesting a dimensional variance. It is request to change the message displayed on a non-conforming pole sign.
All right. So, Madam Chair, this, and board members, this is a little more cut and dried than the last one.
We're so sorry.
But it is a little, lengthy, so.
Our meetings are usually like, not like this.
Essentially, what the applicant wants to do is to put a new face on an existing pole sign. The pole sign itself is non-conforming in a variety of ways that are listed in our review and also in the notice. Your sign, the City of Berkeley sign ordinance is very strict about nonconformities, and in fact says that a nonconforming sign, the copy cannot be changed. So when this came across our desk, it had to be denied, and so then the next step was for it to come here. There are some things to look at. Number one, it's surrounded by Woodward District except for across the street to the east in Royal Oak where it's regional business, and that this is part of a site plan that was approved by the building inspector on July 28th, 1977. And there's a permit and some sketches of that. There's a site plan from 1977, and then there's a building permit for the pole sign since 1978. Again, I'll remind you, as you had a sign that was a little bit similar. You had a sign variance on Woodward the last time, and at your last meeting we discussed that also that your sign ordinance was amended in its entirety in 2003, and likely that's when this nonconformity was created. The site currently has the single pole sign, 3 wall signs facing Woodward, and a single wall sign facing Catalpa. As part of the permit, all of those were asked to be refaced. The wall signs all complied with the current ordinance, so those could be approved. It was just the pole sign, again, in a variety of ways, is non-conforming, including the height, the sign area, the distance from the property line on Catalpa, the distance from the property line on Woodward, and then the radius from the sidewalk to sidewalk intersection. In terms of standards for review, one, the need for the variance is due to unique circumstances or physical conditions of the property. The applicant stated that they need to display the names of current tenants. They note the building is located close to Woodward, which has traffic traveling at 45 miles per hour. In our site visit, we observed that the one-story building at this address is not nearly as prominent as the 3-story building at the southeast of Woodward and Catalpa. The height of the building, its location in proximity to Woodward, as well as the taller building to the south, and the speed of the traffic could all be seen as physical conditions, which necessitate the requested variances. Whether this is the result of actions of property owners or previous property owners, again, I'm assuming it's a previous property owner, but it might be the same property owner, did put up the sign. It was legal at that time, and they are choosing to reface it. Strict compliance with the ordinance will unreasonably prevent the property owner from using the property for permitted use or render conformity with those regulations unnecessarily burdensome. You could see, you could interpret that strict compliance could be unnecessarily burdensome. The applicant stated that due to the location of the building, the speed of the traffic, that their building tenants rely on that pole sign for customers to locate the building. The requested variance is the minimum variance necessary to do substantial justice, as well as the applicant and other property owners, is the 4th standard. The requested variance is the minimum to do justice, since it's not going to increase the nonconformities, they're just changing the sign faces. And that the requested variance will not adversely impact surrounding properties. We don't feel that it would adversely impact surrounding properties, but without the variance, the sign itself could become a blighting structure. So we would ask that if you choose to grant this variance, that you determine if there are unique circumstances or physical characteristics of the property, and that we recommend the motion limit the changes to the pole sign, that changes to the pole sign to changing the message on the pole sign, and if that pole sign is replaced, that it be within compliance with the sign ordinance at the time of the application.
Okay, any questions for Ms. Minnock from my fellow commissioners? We will now call on the petitioner. If you would like to come forward, state your name and address for the record, and tell us a little bit about what you are proposing and what you are requesting, please.
Good evening. My name is Dustin Kennedy, 42319 Addison, Canton, Michigan. As previously stated, we're just looking to change the copy. We have a tenant who had vacated premises over 8 months ago, have a new tenant in that location, and they actually have customers from the former tenant trying to come into their location, even though the MI Sleep Clinic is no longer there and hasn't been for 8 months. So it's a nuisance to the new tenant as well, with bad copy on the sign. And that's all the variance really is. We're trying to change the copy, update it so that people driving can see the current businesses there. And one thing that wasn't explained is we actually have an outbuilding that's off of Woodward that sits behind the Woodward section of the building. That's also a single-story building. They would have zero exposure to Woodward Avenue. No way for anyone to find that they're even on the property. You know, and again, that causes that tenant business, and they vacate, and we have a hard time filling that space as well. So really, we're just hoping you take it in consideration and let us do the variance and go ahead and update our signage so it's all proper.
And in 2 hours, we'll let you know.
Thank you. I'll be waiting.
No problem. All right, do we have any questions for the
I did
petitioner?
have a question.
Mr. Gazand?
I'm sorry. This is just going to be a static sign.
Yes.
So it's not going to be digital.
No.
Okay.
We're literally just changing the copy on the panel.
Okay.
Okay. Anyone else have a question?
Nope.
Okay, thank you. We will move on. I will close that portion of the hearing and open it up to the public. If there is anyone here who wishes to make a comment, if you could please come forward. Sure.
I'm Sarah Zertez. I live at 52 Oakdale Boulevard in Pleasant Ridge. I am the general counsel for Health Call of Detroit. We are the tenant at 28105 as well as 28139. Our other location is 28,000 Woodward on the east side, which is Royal Oak.
Signs of fun. It's this late.
I just wanted to make the record as to what we do there and why we need to change it. We are a community health care and behavioral services provider for high medical need pediatrics. So on the Royal Oak side, we see patients, that's clinic space. On the Berkley side, that is our administrative staff and our training center. So we provide nurses at that location with respiratory training. How do you, when a baby comes out of NICU, PICU, how do you run a home vent? We do trainings on multiple types of vents, BLS, first aid, employee onboarding. We employ about 400 nurses and behavioral therapists in southeastern Michigan, and that's where the training happens. It's all by appointment. It's a secured building, all for good reason, because we do offer pediatric mental health on the Royal Oak side. And what is happening currently is ever since we took over the additional suite, but the signage has not changed, we constantly have people trying to get into our secured building, and it has become a big nuisance for staff. We don't man a front desk at that location because it is by employee or by appointment only. So it's HR staff and executive staff that are getting up numerous times a day to go tell people that the MSC sleep apnea shop or whatever it was is no longer there. So we just wanted to replace the panel.
All right, perfect, thank you.
Thank you.
All right, we have no other people from the, or no one else from the audience who would like to come forward and speak. We have no communication, am I correct? We
No, ma'am.
didn't have any in our packet, we have not received any. I will go ahead and close the public portion of the meeting and open it up to my fellow commissioners for questions, discussions, or a motion to approve the dimensional variance request to change the message displayed on the non-conforming pole sign.
I don't see any reason not to. I mean, I don't see any reason not to change the wording on the sign. As long as they
So-
don't change the sign itself, the height.
Can you make a motion then to,
I'll make a motion to approve the variance and take into account the recommendations of only changing the copy or the facade, or whatever you want to call it, on the sign. If anything else is changed, then it has to meet the current ordinance.
okay?
Support?
Motion by Wilner, support by Ward.
No other discussion from anyone else? No questions, comments? If not, then I will ask you to take a roll call vote, please.
All right. Wilner,
Yes.
Ward,
Yes.
Bueller,
Yes.
Riley. Oh, no, Sarah.
Yes.
McAlpine,
Yes.
Krug,
Yes.
Gesund.
Yes.
Motion passes 7-0.
5 minutes, you guys are good. Thank you.
I wish they were first.
I know, I'm so sorry. So you guys are all set, thank you. Next up would be any other business that we have to attend to. Is there any other business? We have no other business. Next up would be a staff or a board member report.
I am 90% sure that you will have a sign case for your June meeting. Aquatots is a multi-unit building.
It's
They-
the old Farinas, isn't it?
Yes,
Yes.
they came in for a sign for Aquatots, but that, we pointed out to them that they were using then almost all of their signage for the whole building.
So similar to what we just addressed.
Similar to what they, so they're coming in with a sign plan that you would look at, and then there would be specific spots and square footage that would be identified.
Perfect, that would be good, okay. Nothing else?
Nothing else.
Okay, thank you. Mr. Hennon, or Councilman Hennon, you are here. I don't know if you have a liaison report that you'd like to give.
I have nothing, thank you.
All right, thank you. I will open it up to see if there's any public comments, but we have no one in the public, so I will go ahead at 9:04 and adjourn our meeting for this evening. We will see you all in June. Thank you very much.
Oh, also, if anybody wants, I have 5 copies of the Michigan Planner, and there are 7 of you, so I felt like I couldn't.
I get it mailed to my house.
I do too.
right
I feel like
from
I do,
them, so-
yeah.
I'll pass, thank you.
Anybody?
Take one, my kids
Okay.
will rip it up.
Arts, places, planes, and people.
All right, thank you, everyone.
Thank you.